So this is the first of a series of 4 short guides to TUPE and outsourcing. Now the government's about to introduce some significant reforms to TUPE which are due to come into force on the 31st of January. So this is a really good time to brush up on how TUPE works, and hopefully this useful guide will help you to do that, not just in terms of how the law works but how you apply it to practical commercial situations and how you deal with the HR processes involved. So what is TUPE? Well, it's a piece of legislation that aims to protect employees' rights where there is a change in how services are provided to a business. It can also apply in other situations such as business sales and insolvencies, but really our focus here is on TUPE and service provision changes. When we talk about a service provision change, this simply means a change in who performs certain activities for a customer. Now this could be anything from IT services, catering and canteens, receptionists, security services, anything like that. But the important thing is that the entity carrying out the services changes from one provider to another. It typically happens in one of 3 scenarios. Firstly, there's an outsourcing whereby a customer has done activities itself in the past, for example its own IT services, and it decides to contract those out to a specialist provider. Secondly, there could be a second generation outsourcing or a retendering as we call it, whereby services such as IT are carried out by an existing provider but the customer wants to move to a new external provider. Thirdly, it could be an insourcing, whereby services currently provided by an external provider are effectively brought back in-house by the customer. Well, no, in many circumstances TUPE will not apply, and this may be good or bad news for your business depending on what it wants to achieve. There are a number of tests to satisfy in determining whether TUPE applies to service provision changes. I think firstly and most importantly, the activities proposed by the new provider must be fundamentally the same as those carried out by the existing provider, and the government has made that very clear in the new TUPE legislation. I think this can be a difficult test to satisfy if there's more than a minor variation in the services that are going to be provided. So for example, you may have a company coming in to provide services in a more streamlined fashion. They might have a new and better way of doing things. And this may mean that the services that are being provided after the service provision change are not fundamentally the same. Typically this might also happen where, for example, a greater use is made of technology and fewer employees are required to do that kind of work. Secondly, it's important that the employees are deliberately put together to perform those services for that particular customer. So if, for example, you had a company providing security services to, say, the Olympic Stadium, then you would ordinarily expect to see them organising their security guards as an Olympic Stadium security team. So the organisation of the employees cannot just be a matter of happenstance. Thirdly, TUPE does not apply to short-term tasks or single discrete projects. So if what you're actually contracting out is a single event rather than ongoing services, then TUPE may not apply. And fourthly, to be caught by TUPE, an employee must be assigned to that particular team. So this is really the question of who transfers. If the employee is wholly or mainly assigned to performing their work for that particular team and for that particular customer, and the team satisfies the test for transferring under TUPE, then it is likely that employee will go across. I think TUPE has a reputation for being unnecessarily complex and mystifying, but if you look at the legislation, it's actually fairly short, and I think we can really boil it down into 4 key principles. Firstly, the employee's employment will transfer automatically to the new service provider on its existing terms and conditions, and this is really just a neat way of saying that employees are protected from dismissal and any changes to terms and conditions. 2. The new service provider inherits most of the employment liabilities that the old employer would have had, so it effectively steps into the shoes of the old employer. For this reason, there are often commercial indemnities between the parties agreeing who should pay for what in the event of a dispute. 3, the old employer, so the outgoing employer, must provide certain minimum information to the new employee and to the new employer to allow them to find out more about the workforce it may be taking on. And finally, the outgoing employer and the new service provider must inform and consult on the proposed transfer with appropriate employee representatives. No, it's not as simple as that, but it is a very good starting point. And if you can remember the 4 key principles I've just outlined, then you'll have a very good understanding of how TUPE works, and you'll be able to deal with it in practice very effectively. I think there are some areas that deserve more attention, particularly in light of the recent government changes, and those really are the focus of the other 3 sessions in this series. We're going to be looking at how dismissals and changes to terms and conditions work on TUPE transfers. We're going to look at the typical commercial considerations that impact on TUPE transfers, and we're going to look at the practical issues in terms of actually implementing the TUPE process and dealing with the employees. So what are my 5 top tips for dealing with TUPE and outsourcing scenarios? So we obviously set out the fundamental principles of how TUPE works, but I think when you're actually implementing or involved in a service provision change, there are some very key, important practical considerations to remember. The first one is do not automatically assume that TUPE applies. I've already mentioned the various tests that must be satisfied, so you'll need to look very carefully at the work is being done now and the work that you want to be performed in the future. Are there significant differences that the new service provider will bring which may mean that TUPE does not apply? How is the work currently organised? Are there any employees who are wholly or mainly dedicated to performing that work? And this type of exercise will allow you to identify potential employment liabilities at an early stage, and that in turn will help you to deal with a more important commercial question, which is whether you want TUPE to apply. And that really is my second top tip. Actually just consider what you want to happen. So if you are a customer, for example, you may not want the employees to transfer across to the new service provider because the very reason for changing providers may be because you're not happy with the level of performance. So if the employees turn up at the new service provider, that's still a bit of an issue. Similarly, if you are a new service provider, you will need to consider whether you actually want to inherit any employees. You may have sufficient capacity within your existing workforce to be able to take on the work without needing to take on additional employees. Alternatively, there may be 1 or 2 key employees who have a lot of expertise that will help you in providing those services in an effective manner. Thirdly, I think it's really important when you're negotiating a services agreement between a new service provider and a customer to take the long view. It's often very tempting to focus on the short and medium term, what happens at the start of the relationship and what employment liabilities will transfer across and who will pay for them. But it's also important to consider now what will happen at the end of the service arrangements if those services are going to a new provider, for example, what happens if TUPE applies, who pays for the various liabilities, and what happens if TUPE doesn't apply, who will pick up any redundancy costs. Fourth, and particularly important for customers, I think this is to ensure that you deal with any transitional arrangements from old service provider to new service provider in an effective manner, and really to make sure that you are maintaining a high quality of service during that transition period. And finally, I think very important to plan ahead and leave plenty of time to deal with TUPE and employment issues. They can often be lost in the general melee of commercial negotiations. Obviously, TUPE is only one part of the commercial negotiations regarding new services, but it's really important to identify employment issues at an early stage so you can then deal with them effectively, both in terms of the commercial indemnities you might be agreeing and in terms of any employee issues that may arise during the TUPE process.